Saloni, I've shared the draft with Manya. Uh, you can take the
Okay,
draft.
okay, sir. Just give me 2 minutes.
Thank you.
So is it visible?
Yeah, is it visible? Thank you, Saloni. Uh,
Thank you, sir.
so I'll say, and then you'll change the slide, right?
Yes, sir.
Okay, thank you. So, good evening, everyone. As Saloni has already introduced me, so I don't think I should introduce myself again. However, I'm Ritesh Kumar. I work at Sujata Chaudhary IP Attorneys as an associate, and this is the last session, and I'll be explaining you all about prosecution and enforcement of the trademarks, how it is done, how and what we shall do to prosecute and enforce the trademarks. So I've already shared my PPT with you, which I have prepared. I'll be going through the PPTs. If you have any doubt, you can ask in the end of the session. I'll be explaining everything. Whatever you have doubts, we'll discuss this. Okay. First, I'll be starting. I guess means in earlier sessions you must have learned about how trademark application is filed and all the procedure of filing a trademark application. So what happens if you file a trademark application? What happens after that? Filing of a trademark application does not give you a right over the mark. Means you cannot register the mark just after filing a trademark application. There are other procedures also. So what happens when you file a trademark application? Your mark has to be examined by the examiner of trademarks. So, what are the grounds on which your trademark examiner will examine your trademarks? So, the Trademark Act has means provided grounds on which your trademark can be refused. So, there can be two grounds. First is absolute ground. Second is relative ground. So absolute grounds have been defined in Section 9 of Trademarks Act. It's a very vast section. If we interpret the section, I can the session can go only on Section 9 if we want, and Section 11 also. But I have concised it so that we can have a basic understanding of what Section 9 tells and why absolute and relative grounds have been laid down in our Act to refuse the trademark and to maintain the sanctity of a trademark register. So section 9 tells means what are the absolute grounds. So there I have demarcated in three pointers, that the first ground is marks that are devoid of distinctive character. The means the section tells your mark shall be distinctive. You cannot have a indistinctive mark registered. Second is marks that serve designate the kind, quality, intended purpose, values, geographical origin, or the time of production of goods. Marks which are customary in the current language or established practice of trade. So these three basic grounds will says that these are the absolute grounds. If your mark fits in these category, your mark cannot be registered. So you cannot defend your mark if the means your mark has fits in these three categories, and then your mark has to be refused no matter what. Second is relative grounds under section 11 of Trademarks Act. It says that marks which create confusion in the public. So marks such, such as if you have registered a mark, if you are applying for registration of a mark such as 7 due, you have taken 7 up, you have taken 7 from 7 up and due from mountain dew, and you have made your own mark 7 due. So there is chance that your mark is going to create confusion in the market. People will understand that this is some product related to means the company which manufactures dew, mountain dew, or 7 up. They have made some other product with names such as 7 dew. So it is going to create confusion in the public. So 7, you cannot register 7 dew in the market. So it will be refused on this ground. The another ground is marks that are identical similar to other marks. So again, there are a lot of marks which on register that are already existing. So you cannot register a mark which is already which is identical or similar to any mark. Suppose again you file a mark Coke. I know Coke can be a descriptive mark and Coke can be a generic mark, but again Coca-Cola has registered this mark and Coca-Cola has rights over Coke from very long time, and it can be called as a well-known mark and people associate Coke with Coca-Cola only. So the moment you file a trademark application, it is identical to a mark which is already registered by Coca-Cola company. So you cannot register a mark which is already similar. This is just one example. There are a lot of examples. If you means go, if you face the practical situation, if you file a trademark application, you will see that how trademark registry cites marks against your application, and you can have multiple citations against your mark and you will have to explain that why this mark is not identical or similar to the cited mark. Again, the third point is that the marks that are liable to be presented by passing off or the copyright law. So again means you in the later part of my lecture I'll tell you what is passing off. But again, this is a very tricky part, that your mark shall also not be against a copyright law. So suppose there is a mark which is not registered, like suppose if you know about American Eagle Outfitters, you have seen a flying eagle mark. They use a flying eagle. They have a copyright over that mark. So if they have no trademark registration of the mark, but if it has copyright registration, that mark, then your mark can be refused on the basis that a copyright already a copyright mark has been registered under the copyright law, and your mark is similar to that mark, therefore your mark can be refused. And also if registrar thinks that there is a mark which is being used but it has not been registered in trademarks register, but the mark can be cited against your mark, that it is in use and it has the mark is distinctive which has been cited against your mark. So these three criteria under relative grounds shall be fulfilled, uh, shall not fit in your marks criteria to safeguard your mark against these relative grounds. So I guess you have understood what are absolute grounds and what are relative grounds. Under absolute grounds, your mark has to be refused no matters what. Means the word itself tells that this is the absolute ground of refusal. The second is the relative ground of a refusal. Now we have understood that what are the grounds on which your mark can be refused by trademark registry, but how will you overcome the uh, how will you overcome the uh, what we call the objections by trademark registry? So there must be some way, because every day thousands of applications are filed, and thousand against those applications these grounds are cited and objections are raised by trademark registry. So how the applicant of those marks or the councils defend those uh, defend those marks against these objections? So there has to be a way. I know, I understand, but what are those ways? I'll be telling you here. So I'll tell you first, in cases of absolute grounds of refusal, what can we submit? I'm going to tell you very briefly, because again I'm going to tell you each and everything about the submissions, that what we submit before trademark registry to just get over the citations, or get over the objections by trademark registry is can be very broad. It's a very broad criteria, and the arguments can be very broad. But I'll tell you in very brief that what we argue in case objections have been raised by trademark registry. First, I'll tell you, trademark registry can raise both the grounds of objection. Means yes, your mark can be refused under section 9 absolute grounds and relative grounds at the same time. So, like there will be objections of section 9 and there will be objections of section 11. Suppose there is a mark, I'll take an example of a mark. This is a word called procreate, Procreate. So if trademark registry thinks that this mark is generic with respect to the class which you have applied for, Okay, so what registry can cite means object is your mark will be objected under section 9, section 91A and section 91B also at the same time. And then again, if registry finds out that there are other marks which are already registered prior to your mark, and they have been they are being used, or there is a prior registration of that mark and the mark is identical to that mark which is already existing in the trademark registry, then your mark then that objection will also lie in your examination report issued by trademark registry. So you'll have to defend both the objections. But what will you how will you defend in cases of absolute grounds of refusal? You'll have to show, I'm not telling it on my own, these things have been written in the trademarks act, and you'll have to go through the trademarks act for further information. But I have briefed it down in pointers to means show that what we can argue and what we practically argue when citations are when there are objections by trademark registry in the examination report. So you have to show so that the mark has acquired distinctiveness, distinctive character as a result of use before the date of application. So what happens sometimes the marks are filed on proposed to be used basis, but although and some marks are filed with user date, so you can show that the mark was being used, and after the use of the mark the people at large or people associated with that particular trade or what particular classification of goods or services do associate that mark with the applicant only. You'll have to show use, you'll have to show the advertisement. There are different criterias on which in which you can show that you can show investment or advertisement, recognition in trade circles, channel of distribution, and relevant class of customers. Let's for example, I'll again cite Pepsi. You have I'm not telling this mark is not distinctive, I'm just giving an example. You have means Pepsi comes up and files an files a mark, a slogan, dil mange more. Trademark registry can think that this mark is not distinctive. It's a slogan mark, and Dil Mange More can be used by anyone. So Pepsi the mark will be objected against section 9. Section 9. Yeah, in case someone has already registered Dil Mange More, or let's suppose Dil Mange only, and then there will be section 11 objections also. So what will Pepsi do? Pepsi will show that how Dil Mange More is associated with people at large by with Pepsi only. Pepsi has to show advertisements done, investment on that mark done, and how people associate with that mark, means the consumers associating Dil Mange More with Pepsi only. Based on these submissions, Pepsi can get over the objections, and the mark can be accepted and advertised in the trademark genre. But there might be possibility that you will not be able to show that your mark has acquired distinctiveness. However, we submit that the mark has been uh, adopted honestly and with a bona fide intention to use. But you'll have to means to get over the objection, you'll have to show that why the mark has acquired distinctiveness. Otherwise the hearing officer at the time of hearing can refuse your mark, which I'll tell you what happens after means submission of the arguments. Coming to the relative grounds of refusal, you'll have to means what we show sometimes what happens that mark has been cited, which is we have filed a word mark or a device mark, and a word and other device mark has been cited against us. So we compare the device mark with the other device mark. How our device mark is different from the other device mark which has been cited against us. But in case a word mark has been cited against us and that is used from that has been registered from a very long time, then it is very difficult to overcome that objection, because the registrar will be of the opinion that this mark is on the register for a very long time, and you cannot register identical trademark with in the same or similar for the same and similar goods. But yes, again we can argue that there is this Nandini judgment of Supreme Court, that if we can distinguish that the goods or services are different, if we have those sometimes we apply for very specific type of goods. It means in any class there's a broad classification. There means There are a lot of goods in single class. Let's suppose in class 5 only. Class 5 deals with pharmaceutical products. So what happens, sometimes a product has been registered, let's suppose calpol. You must be knowing about calpol. So calpol is used for use in fever. It's a pharmaceutical, it's a paracetamol. So what happens, calpol, if someone comes and apply for a veterinary product, veterinary medicine for, means, which will be calpol for, will be used for uh, cows and all. So it's a totally a different medicine, means, so there cannot be so good, the goods are different. Means the calpol already existing by whatever company will be used for fever for humans, and the other calpol which the other applicant has filed for application will be used for animals. So the person, if the this calpol which is has been registered on trademark registry for a very long time is cited against the other calpol which has filed for application, then they can come and argue that yes, this calpol is used for human, while the other calpol which we have applied for you is will be used for veterinary products only. So they can overcome this objection by stating the by arguing that the products are different. But if you have applied for same goods or services for a mark, and the mark is also similar or identical, then you'll have less, you will not have that better chance to overcome the objection. Then what if, means, there can be two scenarios in this case. Either your mark will be refused after you have submitted, after you have submitted your arguments. Yes, you must be knowing about the natural justice principle. You'll get chance to you'll be heard by the trademark registry. A hearing officer will be appointed. He will hear you, and before after hearing, if he's satisfied with your arguments, either he can accept the application or he'll refuse it then and there. After refusal, you have, means, option to file a application for review, or you can file an appeal at the high court, means at whatever jurisdiction the trademark registry is. If your mark has been accepted, and then the mark will be advertised in the trademark journal. So what happens now? Your mark has been accepted. Registry has no objection anymore that your mark is not distinctive, and your mark is not similar to any other mark. Your mark has been accepted and advertised, but then also you have not registered the mark. There is the mark will be open for opposition for 4 months by third parties now. Now, although registry has understood that yes, your mark is distinctive, and your mark is not similar to any other good, but third parties can come and oppose your mark. Now, the in that the third parties will do check their journals and see if any other similar or identical mark has been advertised by any third party or not. So any third party can come and oppose your mark. So what happens now is, uh, you must be thinking, ki, who can oppose the mark? If I have a registration of a mark, let's for example, I'll give an example of Calpol only, and by some reason, some way, someone has got his mark accepted and advertised for the pharmaceutical goods only, which will be used for human. But now I'll have the chance, I'll see that Kalpol belongs to me and I can file an opposition against the mark. But what happens, sometimes recent trends I'm seeing is that people are filing application for the mark such as trademark, well known. These mark, can anyone oppose that mark? Yes, if you think that you are a person aggrieved, means there might be a possibility. If someone files a trademark for metaverse, metaverse is a generic word and it can be used for anyone. Means, like for example, yesterday only I was getting confused with meta only. There was this stall at some event, and meta means Facebook is now meta. So meta has this stall there. So I was getting confused. Is this meta means Facebook, or some metaverse is stall there, means the stall in metaverse? Because now what is happening, that every company is adopting metaverse. So it was confusing for me. So what happens if meta someone files application from metaverse, and I think that this mark shall not be registered by anyone, because anyone can use that mark in future, or this mark is generic and this mark shall not, no one shall get exclusive or statutory right over that mark. Then I can file an opposition that based on my based stating that this mark is not distinctive under section 9 and this mark shall be refused. But yes, I have filed an opposition within 4 months of statutory period. And and there is this then we can understand, we should know that timelines also. Let's suppose there are 4 months to register a mark, to file a opposition against a mark. But uh, can these 4 months be extended? Uh, these 4 months cannot be extended. These 4 months are non-extendable. You means if you have seen a mark that is that shall be opposed by you, and from the date of publication of the mark in the trademark journal, if 4 months period has passed and you have not opposed the mark, now you cannot go and oppose the mark. You cannot file your rights will be closed to oppose the mark. But yes, there are other rights also. You can file cancellation, but again, that is another story. We'll be focusing on opposition only. So what happens, you have opposed the mark. So now there will be service of your notice of opposition on the party which has filed the application of the of that mark. So your notice of opposition will be served by trademark registry to the person who has filed the application. Then after service of that notice of opposition, he will have has 2 months to file his counter statement. So what happens, he'll get 2 months to file his counter statement. So now he'll have to rebut your he will have to mean submit his submissions, and then he'll have to rebut your notice of opposition, that he'll counter your each and every argument which you have taken in your notice of opposition. He'll have to explain that why this notice of opposition may be frivolous, has no base, and shall not be entertained. Then the applicant will file his counter statement. Then he'll file his counter statement, and then the opponent who has filed the notice of opposition will be served the counter statement. And after the service of the counter statement, that notice of that counter statement, the opponent has to file his evidence in support of opposition. So what happens, I just told you about Calpol. Let's suppose Pepsi. So what happens if Pepsi has filed a notice of opposition based on Sepsi? Maybe if Pepsi might think that Sepsi is confusing similar for the same goods, means someone has filed Sepsi for what we call soft drinks. The Sepsi can be confusingly similar, but it might not be also. But the person believing that it's a frivolous opposition. However, I'll give you a very practical scenario where means I was involved in that opposition. What happened, you must be knowing about Akash Institute. They provide education services. So what happened, there was this application called application in the name of Akashic. And Akashic is a totally a different term. What happens, Akashic is a different term, it has a different meaning, and the services which was provided by Akashic was for spiritual teaching. Means it was totally different uh, mark, means according to me, and a totally different services from Akash. But however, Akash Institute chose to file opposition uh, against Akashic. So, and I was analyzing the opposition, and then I got to know that Akash Institute only owns trademark registration for the device Akash. Means you must have seen the blue color Akash which they write, and they have a device registration. They don't have registration for the word Akash, means word mark. There is a two vast difference. If you have a word registration, you can claim exclusive right over any device or anything. But if you have a device registration, then you'll have to see that can you means you cannot claim exclusive right over the word Akash. However, they filed an opposition against the word Akashic, which was being used for totally different services. Means the service means we had very specific services, and we were never going to so means give services similar to Akash. Means although if Akashic choose to give similar services to Akashic, the words were different, which I believed. We have our means device applications also, and word applications. uh, so what happened? Then I believed that it's a frivolous opposition. So what can we do in cases of frivolous opposition? Before filing our counter statement, because we have to do economic analysis for our client also. So before advising someone to go and file it counter statement and countering those arguments, we should try to approach the person who has opposed our mark. This is one strategy which I believe, and I have means applied this strategy also. Approach these people that and explaining that why they should withdraw their application. And we can also try to settle, means if they have means they want to enter into a settlement agreement also, that we will not enter into their services in future under our Akashic mark also. So these things can happen. We can enter into a settlement agreement, and based on settlement agreement, uh, they can withdraw their opposition. So very easily we can get the opposition withdrawn, and our mark, the registry can order, then the mark can be registered in future. So, however, if the party does not want to withdraw the application under whatever condition, there might be some other regions they don't want to register, they don't want to withdraw their opposition. So, what will happen? We'll have to see that what have they contended in their notice of opposition, and in the notice of opposition will counter their each and every argument. So I told you an example of Akash and Akashic. So we'll analyze the mark, we'll analyze our rights, how we are giving providing services, how we have applied for very specific goods and services. Then we will means we'll have to, and then we'll counter their argument, the how their opposition is frivolous. And for that we'll have to analyze the registry's website, their mark also, their right over their mark, all these things. Like I told you, I analyzed, and I was checking the public search and all. I was checking their rights and on what mark they have means relied their opposition. Then I observed that their mark has been relied on a device mark, and they are claiming right over over the word Akash. Then I thought that can they claim right over Akash? Indeed, they can claim, because they can claim common law rights because they are using the word Akash. However, the registry has they have not got registration of the mark, so they have a little bit means weak rights. If I'll say so, I can argue that in our counter statement. So the counter statement has been filed by me. It has been served to the opponent, and opponent has now filed his evidence in support of opposition. So what will we include in our evidence in support of opposition? First, whatever we have contended in our notice of opposition, that thing has to be supported by evidence in when we draft our evidence in support of opposition. Like you have argued that like you have argued
हाँ तो पर जैसे हमने अभी बनाया है 11 दिसंबर मंथ तो 11 जैन तक लगेगा एक
um,
महीना यहाँ से शुरू है
But still, like within this month, I think like whatever we have planned, all those में dates तो दे रखे थे उसमें बहुत सारे December dates वो थे invalidated. But you don't have to do it like so close to Christmas. We can do it before also. In fact, we can go to Madam Tussauds this week.
डेफिनेटली बुक कर देते हैं
Okay.
Saloni. Okay, so I was interrupted by a voice. I don't know who was speaking, but however, so I was telling about evidence in support of your opposition. So first and foremost thing which we do is that whatever we have argued in our evidence in our notice of opposition, like for example I have argued that my mark is being used, or my mark was first used in 1912. So I'll have to give an evidence that this mark was, because this argument shows that I am the prior user of the mark. And as per Indian law, you know, you might be knowing that a priority of use is considered. Registration has no value if you can show that you are the prior user of the mark. So if you have told that you have been using the mark since 1912, then you have argued to your goodwill and reputation of the mark. You have advertised in different journals, articles, and at a lot of places. You have means you have also submitted to your marketing expenditure, your sales value. So you'll have to provide evidences in support of that. You, like for example, I told you that I have argued about my sales value, that I have sold my product in last 5 economic years for around $2 billion. Means my product is being sold all over the world, and it was the value of the means we have sold for products for $2 billion. So we cannot bring out evidence in support of selling the products in $2 billion, but yes, we can show invoices that our products were being sold in all the jurisdictions of the world. And this is how we can support our argument for sales value, for our marketing value. And you'll have to show enormous goodwill and reputation, and whatever you've argued for your goodwill and reputation, how your market was being used, how people have been associating and are associating that mark with you only. Then coming to the registration of the mark, like for example, if you have if some if in future I have argued that I have got registration of a mark which is and I believe that the mark which has been filed for application is similar or identical to my mark, then I'll have to show that I have the registration certificate of the mark, and when that mark was registered. If I have registered my mark in 1956 in India or in 1916 in India, I'll have to show the registration certificate. Yeah, there might be possibility that we don't have the registration certificate from 1960, so we can take the e-register space and we can show that our mark was registered in 1960 and we have first adopted. So you'll have to file each evidence in support of whatever you've argued in notice of opposition. Then coming to the counters. Now you have seen that the applicant has already countered your arguments and made his submissions. So you'll have to counter his submission in your evidence affidavit, and then you'll have to counter his counters. Means whatever he has countered your notice of opposition, you'll have to deny those claims. That why? But you cannot blatantly deny everything. If he has made any claim which can be true, that you should not deny, you can accept that also, but that happens rarely because we basically deny the claims. We believe that each and every claim is false, and if we believe that that claim might be true, then we'll ask that they are required to file their evidence at means when they have to file the evidence, or for want of knowledge. Means I cannot, means sometimes I believe that this might be true, this might not be true, but then I'll argue that this is not denied, or this is not denied for want, this is denied for want of knowledge also. Okay, so you'll have to consider that what can be denied, what cannot be denied also. You cannot blatantly deny everything. So I've told you evidence affidavit in support of opposition. So you'll have to first submit your arguments, you'll have to submit your evidences in support of each and every submission whatever you have made in notice of opposition. Then you'll counter the arguments of the arguments made in counter statement. Then you'll counter the denials or counter made by the applicant in their counter statement. Now your evidence affidavit in support of opposition has been filed. So what happens this time? What can happen that you will serve the evidence affidavit in support of opposition to the what we call applicant, and he'll has 2 months to file his evidence affidavit. So evidence affidavit in support of application. Now he must have submitted something in his counter statement. he must have argued that his mark is being used. If you have submitted that your mark is being used since 1912, he must have submitted that his mark is being used since 1911. So he has made a submission. Now he has to give an evidence in support of that submission. And then if he has not given evidence in support of opposition, then you can counter that in your rebuttal. That I will tell you in later part. Now let's suppose he has given he has argued that his mark is being used since 2000 only, and and by that use he has acquired distinctiveness. But that he has to submit an evidence in support of that argument. Then again he must have submitted about his goodwill and reputation, what goodwill and reputation he has acquired with his mark, and how he has advertised, how he has been selling his mark, how he has been marketing his mark. So all these evidences has to be colluded in evidence in support of application. Now he'll rebut your submissions made in your evidence affidavit, like evidence in support of opponent, and then he'll counter again your counters. So there are three part of evidence affidavit also. First, he'll submit his evidences in exhibits, then he'll counter your submissions in evidence affidavit. Then he'll counter whatever you have countered in evidence affidavit of opposition. Now again the opponent gets one chance to file his evidence. So he will have 1 month to file his rebuttal evidence in reply, or means basically they rebut and they file additional evidences if they are required to. Otherwise they can file just a letter that we don't wish to file evidence, or we wish to file evidence at the time of hearing. I have this evidence part is complete. Now what happens? Sometimes what happens at the time of evidence submission of evidence, like let's suppose evidence in support of opposition. I don't want to file an evidence in support of opposition. I just want to. Then I have the chance that I can file a letter stating that I wish to file my evidence at the time of hearing. The same is the case with the evidence in support of application. The applicant does not want to file his evidence at the time of filing evidence. He will just send a letter that I'll file evidence in support of application at the time of hearing. And in evidence in support of evidence reply, we can do the same thing. We can file a letter, just a letter. So now what happens? You will have to see that whether the timelines provided the for filing all these submissions can be extended or not. These timelines are non-extendable. The notice of opposition timeline cannot be extended. However, the to file a counter statement, to file evidence affidavit, you can file extension of time for 1 month, but not more than that. You cannot extend more than 1 month. The moment you extend your 1 month, you will lose your chance to file evidence in support of opposition or evidence in support of application. So you should file these documents within time limit whatever has been provided by the law. So after the evidence stage has been completed, you have argued, you have submitted your evidences, you'll get chance to be heard. Means both the parties will get chance to be heard. So you will argue on merits, or you'll argue on argue on basis of what we call procedural grounds. Sometimes there might be possibility that the applicant has failed to file his evidence, or the applicant has tried to take extension more than 1 month, which is not provided by the law. So you can argue on the basis of procedural grounds, or then otherwise you'll have to argue on the merits. What will be the merits? Whatever you have argued in your notice of opposition, evidence in support of opposition, and evidence in reply evidence. The applicant will argue on the basis of counter statement, evidence in support of application. That's it. So you'll have to show the rights, and whomsoever will be able to convince the hearing officer will get his relief. Means if the hearing officer believes that the mark sepsi in against the mark sepsi is similar and is confusingly similar to Pepsi for the goods, for the soft drinks, so the hearing officer will refuse the mark. And if the hearing officer is if the applicant is able to convince the hearing officer that the mark sepsi is not similar or not confusingly similar, then and the he has acquired the Mark Sepsi has acquired distinctiveness by use by all the evidence. He is able to produce the evidences that it has acquired distinctiveness. Then the mark can be further registered. So this is how registration process is done. Okay. Sometimes what happens, although it what happens, there is a frivolous opposition. So although there is a frivolous opposition, I told you, can settle the matter. If the party is not settling the matter, you'll have to argue, and at the time of hearing you can means conclude your submissions in a way that you can show that this opposition was frivolous. Like I told you, the mark Akashik and Akashik, the opposition filed by Akash Institute, I believe was frivolous. So, sometimes what happens means this was although means right opposition, but sometimes what happens that people file opposition for this just creating pressure or just to block your mark. Sometimes what happens, I have filed 10 application for a mark. So what happens if someone does not want that your mark shall be registered, they'll just file opposition just for the sake of blocking your mark. Although means I have filed a mark for takeaway, let's just example takeaway, and I have filed in all the classes, like I have filed means all the 44 classes, whatever classes are available. Someone can come means although they don't have right over all the classes, they can file opposition against all those classes. So we can argue that the opposition is frivolous. Further, based on at the time of hearing, we can overcome that opposition. Further, now the opposition stage is complete. Then comes what infringement actions and passing of actions. Saloni, can you change the slide now? Or Manya? Now. So we'll understand what is infringement and passing of actions. Guys, I'll take a minute actually. Sorry guys for the interruption. Now coming to now all the uh, opposition proceeding is complete. Either your mark is refused or mark is registered based on your submissions and arguments. If you're an opponent, you can get the mark refused based on I told you how you will submit your arguments at the time of procedure of opposition and after the hearing. So this is how it takes, means it takes a lot of time in cases of opposition. If you file an opposition, it takes 2 to 3 years. Sometimes it takes 10 years also. Means I have appeared in hearings recently which there were means the applications were filed in 2010 and the opposition was filed in 2012, and I appeared in hearings. It is more than 10 years, I guess. So whatever, this is how trademark act in India works, but this is how you can operate in opposition proceedings. Now what happens if you want to file a suit, means a case in cases of infringement or passing off? Before going to infringement or filing a case of infringement and passing off, we will have to understand what is infringement and what is passing off. So next slides, please. Manya, can I have the next slide? Thank you. No, the infringement one. Thank you. So we'll have to understand what is trademark infringement. So the only difference between a passing off and a trademark infringement suit is that if you have a registered registration of trademark, then you can file a infringement action against infringer. Let's suppose what means, however, your mark has to be similar. The mark which against which you are filing has to be will shall be similar and identical to your mark. Let's suppose again there is this mark called bet no wait. Someone has filed uh, uh, you have filed bet, you have a registration over a betnovate mark, means BETNOVATE, and someone files a mark called uh, with starting with VET. Now there is similarity, means your mark is pronounced as betnovate, the other mark is vetnovate, but there is the mark is confusingly similar. So what can we do in that situation? You have a registration over the mark and you have registered your mark since 19 around 1950 or 55, something like that. So you have means your mark must be very your mark must have acquired this must be well known also. So based on all your rights, you'll file an infringement suit against that person. But what happens if you have not registered your mark? And like for example betnovate, you have never cared to file a registration application for registration of that mark, and now that mark is being used by you, that mark is being used by someone, and he has filed an application for registration also in the trademarks registry. Now you will, based on your use, you'll file a infringement passing off suit, not infringement suit. So infringement has been defined in section 29 of Trademarks Act. So you'll have to show that the mark against which you are filing a suit is identical or deceptively similar to the registered trademark and is in relation to the same or similar goods or services. Like for example, if someone files a trademark for Betnovate for chocolates, then in that case you'll have to show that your mark is well known. Like for example, betnovate, it's a pharmaceutical product. So in cases of pharmaceutical products, the stand of codes are like that, that they take utmost care shall be taken, and chocolates are edible, the medicines are edible. So there might be a possibility that court will consider this argument and they can injunct the mark. However, betnovate is a well-known mark. Bet means a lot people associate Betno with the company which has the registration of the mark, which uses the mark. So in whatever class or goods you file a mark, file Betnovate mark, means whatever class of goods, means either for your software in class 9, 12, 16, whatever, means for whatever class you file, you file or you are using, you can be injuncted. But for example, if some mark is not well known and someone has filed an application or someone is using your mark, like what we call, there's this mark called tripler. Okay, so what happens if there is a tripler mark and you have a registration, you have a use, but your mark is not that well known. You are using it for let's for example, electric bikes, and someone has filed application for tripler for edible goods or some foods, chocolates or something like that. So you cannot stop the person who has filed application or who is using the tripler mark for edible goods or chocolates. You are using for electric bikes only because you have not acquired that distinctiveness that it can confuse people with your electric bikes. So you'll have to see these criteria before filing an infringement suit against someone in the court. So and then again, you'll have to see all the services, goods, means your rights have to be analyzed before filing a suit of infringement. Uh, then if you file infringement suit against someone, you then first there are three criteria which the court undertakes, means court sees to give you the reliefs. First is there shall be a prima facie case, means at the time of first day of hearing you'll have to show that there is a prima facie case, your rights are being violated, you means you are facing a lot of damage, means and your marks are being infringed and if the party who is infringing your mark is not injuncted and you do not get relief, then you are going to face a lot of difficulty. So at the time of hearing, you'll have to show that there's a prima facie case. Then you'll have to show that balance of convenience lies in your favor. Let's means uh, what is balance of convenience, and how you will show that balance of convenience lies in your favor. You'll have to show that if the mark is injuncted, if the person who is using your mark is injuncted, he will not face difficulty because he is riding over my goodwill and reputation. But if the person if the person will not be injuncted, I will be the person who will be in more difficulty. My goodwill and reputation can be tempered, and I have been using this mark since hundred of years. So I will be the one who is not going to be convenient if the person is not injuncted, if the person is if I don't get the release which I have prayed for in my plaint. So I'll have to show the balance of convenience. uh, then then I'll have to say that show that irreparable harm will be caused if I don't get the reliefs. Means I'll have to show that beyond means how I will be harmed. I'll have to show that I have means I'm selling my goods for hundred of crores in the market, and if the person who is infringing my goods, who is infringing my mark, is not injuncted, is not stopped the today only, then I can have sale, I can have means less sales also. And sometimes what happens, I am a pharmaceutical company. If I have approached the if I have approached the court for injunction or for whatever reliefs, I have approached the court, and the other party is also a pharmaceutical company and is selling a product with a similar name, and there might be a possibility that the quality of the product can be poor. And if people consume that medicine, believing that that medicine belongs to my company because the mark is similar, so the harm will be on my side. My name will be damaged because people will believe that Cipla's medicine was being sold and I took that for curing my fever, but instead of curing my fever, I suffered from some other element, like for example your liver damage or whatever, because the standard is very high in cases of pharmaceutical products, or maybe the standard shall be high in cases of all the products. Let's for example edible goods also. If you are providing a restaurant services, like for Domino's, recently Domino's got injunction orders against another restaurant which was selling pizza with similar name. So what happens if Domino's has a very high standard of quality of its pizza, and someone is selling a very low standard quality pizza under a similar name, people will believe that somehow this restaurant is related to Domino's, and based on that name, people can go and eat and can fall sick. So you'll have to show that how you are being damaged because of that name. So these three criterias have to be fulfilled in the court just to get infringement, to get your reliefs under infringement. Now coming to passing off. Next slide, Manya. Manya, can I have next slide? Yes, thank you. So now I told you what is infringement. If you have a registered mark, means you have a registration over a mark, you can file an infringement suit. Now what if you don't have a registration of a mark? Like for example, I told you about Betnovate. You are means you're not a registered proprietor, but you are using the mark since 60 years, 80 years, 100 years, whatever. And now you got to know that someone has filed an application or has been using Betnovate, or let's for example Technovate also. It's a similar name, and it is being used for uh, similar goods also. Means they are operating in pharmaceutical only, and they are the preparations of that goods are same. Means like for Betnovate, if I say it's a cream, the other person is also manufacturing cream for similar goods in pharmaceutical. If you will see, there are always, like for example, Calpol, there is paracetamol. So someone files Solpol, and that is also paracetamol, that is also tablet. People are going to believe that Solpol is somehow related to Calpol, and I am selling my Calpol for 2 rupees and someone sells it for 1 rupee. People might buy Salpol believing that it is the cheaper version of Calpol, and it somehow relates, means somehow it is related to my medicine, my company. So people are going to believe, but I don't have registration of Calpol, I don't have registration of Betnovate. What shall I do? Can I file a suit? Yes, we can file a suit under passing off law. Passing off is a law of tort. Okay, law of tort, it gives, it's a common law, right? It has come from means from very long time. If we don't have registration, we can file a suit of passing off. So in India, I was initially telling you that use is the base of base of a trademark. We, although you don't have registration, if I'm a prior user, I don't have any registration of a trademark, I don't have statutory right of a trademark, I can file a suit against anyone, even though you have a registered mark, but you are a subsequent user of a mark. So I have rights. So now it is always argued that where passing off has been defined. So Section 27 of Trademarks Act deals with passing off a trademark. So again, when you approach the court, the standard is very high. If you are filing a suit for passing off, you'll have to prove beyond reasonable doubt these three things: that there is misrepresentation. Means how will you prove that someone is misrepresenting you? Like I told you again, means I am giving example of pharmaceutical products only because it is easy to explain that how someone can misrepresent that this pharmaceutical product belongs to, let's for example, Cipla or Mankind. Like Cipla produces some medicine. I don't know what name, and I don't remember right now. But let's for example, Cipla produces Calpol, although it is manufactured by different company. But I'm just giving an example. Cipla is manufactured by Calpol is manufactured by Cipla. What happens? Someone then here again is manufacturing Calpol only, identical mark. Okay, but in their means, and they are writing that it is being manufactured by so and so company, so and so company, but they are selling identical Calpol. Let's for example, recently there was a case that Gentech, you must be knowing that Gentech has been taken by the company which was manufacturing, taken back by the company which was manufacturing it due to its own reasons. But now what is happening in India, you can easily get Gentech. So how can you get Gentech with the only company which was making, which was manufacturing and selling Gentech has stopped manufacturing it? But there were companies who were manufacturing Gentech, and people were buying it as, means it's a ranitidine tablet, basically used for, means in acidity and all. So now the company came to know that the Gentech is product Gentech is being sold in the market of India. So what it did means it found out that who all are manufacturing Gentech, and it filed a suit. So here the company which found was manufacturing Gentech came to know that there was misrepresentation, that Gentech is being sold in the market, and it should not be done because Gentech belongs to them. And if Gentech is being sold by other people with the same formulations, it can cause harm. Then now coming to, you have shown that there's misrepresentation with respect to the goods being sold by the person who is unauthorizedly selling the product. Now you'll come to goodwill. How you'll have to prove goodwill. Now in cases of Gentech, in cases of like for example Betnovate, you can easily show that how goodwill is associated with the person who's selling Gentech or Betnovate. Like for example, when the argument I was present in the argument only, and the person who was arguing about Gintech and all. So what happened, the judge only observed that there is misrepresentation, because people associate Gintech with that company only which had filed suit. So the judge was of the opinion that even I use Gintech and I knew that this product has been taken back, but if it is being sold, there is and people associate Gintech with that company only. So there and but not means this is just an example. You'll have to show your goodwill, you'll have to show your sales value, you'll have to show marketing value, you'll have to show that how people have come to associate your mark with you only. So let's for example you're in a company, you'll have to show that you are using Pepsi and how people have associated Pepsi with PepsiCo only. So you'll have to show evidences of that. You'll have to means show all the values, advertisements, and whatever the facts and circumstances available with you, means all the internet sources, resources. If your mark has been advertised by some celebrity, if it is being still advertised by celebrity, or it was advertised by celebrity, you'll have to show that everything, whatever expenditure you have made on your mark, to show that the goodwill and reputation is associated with you. Now coming to the damages, like for an example, I told you there is misrepresentation that Gintech, Cobadex, whatever the mark, but no, it is misrepresented by the manufacturers, that this is being manufactured by me and I am the proprietor or of that mark. Now you'll have to show that what damages it does to you, how you'll have to show that what damages it is being done on you. So what will happen now, you'll have to show that if I have taken back Gintech on my own, I am the owner of Gintech. But if someone is manufacturing Gintech, although I have taken back that medicine, they don't have right to do that. Why? Because if they are manufacturing a very what we call very means bad quality medicine, even means they are manufacturing the good quality medicine, what if there is a reason I have taken back that medicine, and we have the responsibility to stop the person who is manufacturing a medicine which is not being used in the market now. So it is creating them. Now people will take Gintech for their relief, whatever means disease they are suffering from. And if they fall sick in future by consuming Gintech, it will cause damage to the company who is the original manufacturer of Gintech. So the Gintech, so I will show that how damage is being caused. So people will say in future that this product was manufactured under this mark. Like for example, a ranitidine tablet was manufactured under Gintech, and it was sold to us, and it was manufactured by so and so company, and so and so company has already closed the manufacture, already they have taken back the products from the market. So now they are going to blame us that we are the one who has been means manufacturing and selling it, but we were not manufacturing and selling it. So it has damaged our reputation. So we have the responsibility to stop that damage. uh, Damage on our company, will have to file a suit, although we are not registered user of a trademark. So these are the three criteria which you need to show in cases of passing off. I'll again repeat, you'll have to show that there is misrepresentation. You'll have to show that your goodwill and reputation is very high, and it is being someone is riding over your goodwill and reputation. And the third point is damages. What are the damages caused due to that the unauthorized use, sale, manufacture of a product under your mark? So I'm done with now infringement and passing off. Now we should know that what are the reliefs, what reliefs we can seek from court to under infringement and passing off suits actions. Manya, next slide please. Manya, can I have the next slide? Thank you. So now, I have been involved in a lot of these suits. So I'll tell you what happens on the first day of the court. So means mostly what happens, we approach the court for injunction, means add interim injunction. On the first day, we try to get an interim injunction. Let's for an example, I'm citing an example like in a case of Pepsi, someone has Pepsi manufactures soft drinks. Someone means has been manufacturing Pepsi for biscuits. So what happens is once Pepsi has a big name, it's a well-known mark. People know that about Pepsi very well. So what will happen if someone is although manufacturing biscuits under the name Pepsi, it is going to damage the goodwill and reputation of Pepsi in future. And especially when the biscuits are of low quality or substandard biscuits are being sold under that name. So Pepsi will have to approach the court. So first thing they will do will they will try to get a and add interim injunction, means injunction on the day of first day of the court, first day of the argument. Okay, sometimes what happen, we get, you must have heard that you get ex parte ad interim injunction. What happens in that case is you might be knowing that what is ex parte, but however I'll tell you, ex parte, the parties don't appear. Like for example, I told you someone is selling a substandard Pepsi biscuit, and Pepsi is manufacturing what we call soft drinks. So the other party might choose to not appear before the court because they are already manufacturing substandard biscuits, although they have been served. Sometimes what happens, the party don't. Sometimes they means they do advanced services of the plane of the suit. Sometimes they don't do advanced services. I'll tell you why advanced services are not done. uh, but in the later part, that what are the scenarios, why do we don't do advanced services of the suit to the other parties. But we can I have told you that we can get injunction on the first day, or means on the first day of the hearing. Then we can get appropriate damages on the first day, but this is not a practical scenario. We hardly get damages on the first day of the court. This is we get damages after the hearing in hearing of application under 39 1 and 2, or after the hearing of what we call the after the trial. Basically, we don't get damages in initial phases. So, and third part is handing over accounts and profits. We can get the accounts and profits of the other parties if we have filed an application for that, or we have paid for that. Then we can get the accounts and profits whatever has been sold. Means if someone has sold Pepsi biscuits, but they have been selling under my name, so I can get all the accounts and the profits they have means made. But it's also not a practical scenario. Some very rarely it happens. Then I was telling you, we don't do advanced services sometimes, and sometimes we do advanced services. Why we do advanced services? Why we don't do advanced services? It's a very practical scenario. I'll tell you why we don't do advanced services. Like for example, we file an application for appointment of local commissioner. So what happens? If someone is selling Pepsi biscuits, or someone is selling some pharmaceutical product, or someone is selling some clothes, means you must have seen counterfeit clothes all the times. Counterfeit of LV, Nike, Puma, shoes, clothes, and all these things. If we send a advance notice to these people will be attending. They will know that a suit is going to be filed or has been filed against us. So they will do, they will hide all those goods which are counterfeits, or which are means infringing goods. So to avoid that, we don't do advanced services, and we approach the court stating that why we have not done advanced services, and why we don't want the party to appear in this suit, because these are the damages, and we want a local commissioner to be appointed in this case. Therefore, if local commissioner will be appointed, local commissioner will go there with the help with police and with the plaintiff's counsel, and they will seize all the goods. To seize all the goods, the local commissioners are appointed. Therefore we don't do advance service. But sometimes what happens, you have been in touch with the other party, you have sent cease and desist letter to them, and you have been interactive with the party. The party must have, sometimes what they do, they say that yeah, I'm going to settle the matter, I'm not going to use the mark, but eventually they means continue the use. So then you'll have to approach the court for suit. uh, then in that case, you means the court will not give you added injunction until unless you have done advance service. So you'll have to do advance service, you will serve the defendant the suit, and then you'll see that the party choose to appear in the court or not, or if they don't, means you can get injunction very easily, but you'll have to serve them. And third, the application under order 39 rule 1 and 2. So you can get you can file an application for add interim injunction, and you can get in interim injunction. Again, you'll have to show that you have a prima facie case, balance of convenience and all these things, and then you can easily get injunction against that party after the argument on application under 39 1 and 2. So these are the things, this is how you file a suit. Again, if you have filed a suit, trial will go on, and then you can get a permanent injunction. You cannot get permanent injunction based on the evidences and the trial, what has how the trial has concluded. And then you can also you can also get damages. You must be hearing these days, means earlier basically I practice on Delhi High Court, so I have seen, means I am seeing that recently Justice Pratibha Singh and all those IPD judges were very active, very actively, means giving damages to the plaintiffs after the trial, and awarding damages. So there were damages, but so you can get damages also, whatever damages based on the calculation and all. So, and other thing is that sometimes what happens after injunction, parties go for mediation also. Section 12A of Commercial Courts Act gives you option to go for mediation, and the party can settle the matter there then and there also. So these are the options in suit. Means most of the time what happens, if you have, means you are a big name, if you're Pepsi, so the Pepsi biscuit person will want to settle the matter, and this is what shall be done by the defendant side also. They should settle the matter if they believe that they don't have right over the mark. Now coming to the drafting part also, how we should draft our plaints, written statements if you are a defendant, and subsequent documents, replication, and whatever all the documents required. First, you should analyze your rights over the mark. First thing you should do is analyze the rights over your mark. Then again, means I told you how, means you have to show in case of in case of infringement or passing off, that how you'll have to show prima facie case, you'll have to show irreparable loss, and then you'll have to show balance of convenience. To show all these things, you'll have to submit arguments in your plaint, that how balance of convenience is in your favor, how prima facie case is, how your case, you have a prima facie case, and how you are going to means you will face irreparable harm and damages. To support to For that, you'll have to bring in evidences, you'll have to submit each and everything, how you have goodwill and reputation, all those sales figure. Again, means it is almost similar to the evidence affidavit I discussed at the time of opposition proceeding, but not that similar, because that's a tribunal here, means it's a I will call tribunal, but yeah, it's not full-fledged tribunal also. But in court, you'll have to see your jurisdiction part, how means if you're filing a case in Delhi High Court, you'll have to see jurisdiction, that how cause of action has been, you'll have, means you don't create cause of action, the cause of action has been created. There are plethora of case laws also on cause of action, jurisdiction, so you'll have to see jurisdiction. The suits has to be are means are guided by CPC, Commercial Codes Act. So you'll have to see that what provisions lie, how means first and foremost your jurisdiction part means, because sometimes what happens, plaintiffs choose some jurisdiction, means sometimes they manipulate jurisdiction too. That's a very common thing. Recently Delhi High Court has observed that pecuniary jurisdiction, if you know what is pecuniary jurisdiction means, the valuation of the suit. So what happens is that how can we file a suit in Delhi High Court and how can we file a suit in district courts? So your pecuniary jurisdiction has to be analyzed. So based on that, if your valuation of suit is more than 2 crores, so you'll file a suit in Delhi High Court. If it is less than that, you'll have to file, I guess means the criteria has recently changed. There has been revision. So what happens, you'll have to file a suit in district courts. So some parties, what, to get the release means, to get the manipulated release against the defendants, although they don't have rights, they were making jurisdiction, they were decreasing the valuation of their suits, and they were making pecuniary jurisdiction and were filing suits in district courts, in the relevant courts, in whatever courts they have means contacts. I should not say this is a very privileged and confidential thing, but however, uh, so what happened? That is how you will have to analyze your jurisdiction, your cause of action. Then you will come to your submissions in the plaint. You'll have to be very specific about your arguments, that how you have right over the mark, how you have goodwill and reputation over the mark, and why you should get the relief of permanent injunction. Then you should analyze that what ancillaries you should draft. Like I told you, application under 39 rule 1 and 2 of CPC, the you should analyze whether local commissioner shall be appointed or not. You should analyze that uh, documents, what documents you'll have to file. So you'll clear for clearer copies, you'll have to file documents. There are different ancillaries also, you'll have to means analyze all those ancillaries applications, that what application you'll have to file. 4 or 5 ancillaries are there, which means if I explain, it will take again means a lot of time. So I'll tell you, you'll have to analyze all those things, what ancillaries you are going to file with your suit. This is the case with the plaintiff. Then coming to the defendant, if you think that you can contest this matter, some matters are very contested matters. So if a party thinks that, if someone comes and tells that he Gentech means, for an example, Gentech means the company which is manufactures the medicine, means there are third party manufacturers, and it says that I'm manufacturing 12% of medicine in all over India. So the 12% of medicine of Indian medicine is manufactured by this party, and they say that they have right over Gentech, and they don't want to lose the right over Gentech. So what they will do, they will contest the matter. So based on the plaint means, they get time, 1 month time. Means basically it's 120 days altogether time to file the written statement. So they will get under Commercial Codes Act. So they will get 120 days altogether, and they'll file their written statements. So in the written statement, they will again have to show that how they have the right over the mark. They'll have to show the evidences. They'll have to be very specific with the evidences, goodwill and reputation, how they have earned goodwill and reputation with respect to that mark. So again, the same thing has to be followed. Like in plaint you have argued, but in written statement you have to rebut the whatever they have argued. So there will be this section in which they will do admission denials, and the as per the Commercial Codes Act in Delhi, as I'm telling about means Delhi's practice. So you'll have to file documents for admission denials. So there is a separate document as per Commercial Court Act. You'll see that how admission denials are filed. So you will have to deny the documents also, whatever the documents they are filed. But again, there are judgments which say that uh, which say that you cannot blatantly deny all the documents. You'll have to see what documents means. If I have a registration over a mark, you cannot deny a registered means a certificate. That's a government document. You shall means think about denying before denying any documents. But if there is a document which is a photocopy, I can deny that. Means I cannot I cannot trust that document. That's a photocopy document, I cannot trust, so I will deny that. But the original, if someone has filed some original documents which has been issued by court, when someone has filed a judgment, a copy of a judgment issued by court, I cannot deny that because that's a government document. That's a document which has been issued by court, and how will I deny that? So you'll have to take care that what shall be denied, what shall not be denied. After written statement, the trial phase followed means I can file my the plaintiff gets chance to file his replication. I'll file replication to the written statement, and if they have filed any additional application. So what happens if you have filed written statement? Sometimes what happens if you believe that the party has no jurisdiction or the suit is frivolous, the suit is very frivolous and they have filed just for the sake of it. You can file an application either to return the plaint or to reject the plaint. So there are order there are procedure laid down in CPC in which order 1 rule 10 order 1 rule 11 are the section are the orders in CPC which says that you can file an application for rejection or return a plate. So these will be heard separately, that if you believe that if you believe that there is no jurisdiction, you can file order 1 rule 10 application that this plaint shall be return and we return sorry rejected, and this suit shall be dismissed based on that only. So you will have to analyze everything. Okay, then how you are going to proceed with that? Then if now I'm telling you why you should file a written statement, only because you believe that you have a right. Let's suppose you believe that you don't have a right, you're just a counterfeiter, you're just means, or you believe that there might be similarity of the between the marks. So what shall you do? If I am on the side of a defendant, I'm a defendant lawyer, I'll go for settlement, because there will if I go for if I contest the matter, I'll have means I'll have the responsibility to prove in further trial that why I should not be permanently injuncted. And it does not ends there. Sometimes what happens, the court means award heavy damages, so you'll have to pay a lot at that time. So if you are settling the matter at the time of first hearing, you choose to go into mediation and you mediated, and after the mediation you have settled the matter, you can easily settle the matter in a very less money. So what will happen, you'll save your time, you'll save your money, and you'll save other side's money also at the same time. So these are the reliefs, these are the things you can do from a defendant side. And I have told you what how can you draft and what shall you and how shall analyze your drafts in the cases of suits. Now there's this aspect of cease and desist letters in mostly in intellectual property practices, and especially in trademark law, which we mostly practice. Manya, can we go to cease and desist, the next slide I guess? So I should tell you what is cease and desist letter. Basically, it is a letter to notify the other side, either he's infringer or he's passing off my goods. Let's suppose I came to know about a mark, I came to know about a product is being manufactured, is being sold, is being marketed under my mark. As for example, I'll say Levi's. Levi's is my mark, and I am market, and I saw that someone is manufacturing Levi's. Let's for example Levi's in the similar. You must have seen Levi's mark. I'm giving example of Levi's because you all must have seen. I guess I'm supposing that, or I'm assuming that you must have seen Levi's in the similar red color pattern with white Levi's written. So what will happen if I am manufacturing Levi's under and which is similar or confusingly similar to Levi's, and I came to know about Levi's is being used by someone, and they are means they're a small manufacturers market and doing marketing. So before going into suit, I means I don't want to file a suit against that party. I just means I believe that if I send a letter to them, they might stop the use. So what happens sometimes, someone is has filed an application also, application to register a trademark. Someone has filed Levi's mark to register for under class 25 for clothing. So I believe that the mark is being used. The mark is similar, confusingly similar, and it is being used by someone. So what will I do before filing a notice of opposition? Before filing a suit, I'll draft a cease and desist letter. I'll notify that person about rights in my trademarks. Whatever trademark I have registered, whatever trademark I am using, I'll notify that person. So I'll first of all introduce myself, I'll notify my goodwill and reputation, I'll notify that how Levi's mark is being associated with me only, how I have been using and how I have done marketing, how I've been selling, how I've been advertising my mark. These things I'll specify. Then I'll come to that this is how I came to know about your mark. I so we'll explain that this month we came to know about your mark and how you have been using your mark and all. So now I have told everything about the mark, the unauthorized use or application of the. Then we'll come to the demand part. Will cease and desist letter are basically a demand letter. So what we'll do, we'll demand our means these are my demands. We'll ask them to cease and desist whatever use they have. To if they have a application for the mark, I will ask them to withdraw that application. Then if we can give our additional demands based on the means, we discuss these things with clients also. So means clients have similar clients have some what we call demands, also specific demands. Sometimes what happens that the clients wants to settle the matter when the client wants to buy the mark. Sometimes what happens, the client wants assignment of the mark. So well, we can give that, we can write that in the letter that we want this and this can be done. So basically what happens before filing an opposition against a mark, before filing a suit against someone, we send a letter. Just I also sometimes believe that it is a type of settlement letter, means where we try to settle matter. Recently what happens, I'll tell you a very practical scenario. Now Supreme Court has also given a judgment on section 12A of Commercial Court Act, where you have to go, means mandatorily go for mediation. So what happens in cases of trademark infringement, people don't choose to go for mediation. They basically what happens, they file an application where they means want exemption from mediation. They don't want to do mediate. They don't want to mediate. Just they just don't want injunction on that on the person or on the company at the ad interim stage. So what happened? So now the courts have discussed how means how will understand the matter was urgent, because the exemption application under 12A the 12A exemption application can be given only when we will be able to prove that the matter is urgent. And if injunction is not granted to a party, then will face irreparable loss and harm from the day on. Or we have been facing irreparable loss and harm since the day they have been using the mark, or uh, they have filed application for that mark. But so the courts, so therefore what has happened now, the recent practice or this practice has to be means chosen, that you should send a cease and desist letter to show the court that you have tried to settle the matter. And although you have tried to settle the matter, people the person who is infringing or is unauthorizedly using your mark has not responded to you. Sometimes the other party don't respond to the cease and desist letter. So this is just a proof that the other party has not tried to settle the matter. However, you have tried to settle the matter, so you have let down your demands. You have asked to settle the matter. You have asked them to stop the use. You have asked to you have let down your demands in cease and desist letter, and you show that to the court that yes, we have tried to settle the matter. Other thing is why cease and desist shall be sent to other parties who are mean infringing unauthorizedly using your mark is it's cost effective. What if means your clients have very big rights, means there are a lot of clients. Let's for example Louis Vuitton mark are copied by a lot of people in India mostly. So what happens? Your client has Louis Vuitton. You know the goodwill and reputation of Louis Vuitton. Everybody knows that. So if you send a cease and desist letter and the other party has an party will cease the use of the mark Louis Vuitton. Let's for example LV of Louis Vuitton. It is very means the LV mark is conspicuous in most of the products of Louis Vuitton, and you know the goodwill and reputation of LV also for the sake of means LV alone has a lot of goodwill reputation if we set aside Louis Vuitton. So based on LV only, I try to send a cease and desist letter, and the other party seizes the use. It is very cost effective. You take undertakings from them that in future they will not use the mark. But if they try to interact with you after the cease and desist letter, if they don't interact with you after cease and desist letter, you don't have other option either to file opposition if they have filed an application or to file a suit against them. So uh, I guess this is I have I guess I have justified the explanations also. So now is the time for question and answers. If anyone has question and answer, Manya, can
Yes,
you?
sir. So do we have any questions for sir?
I hope everyone is listening at least. And
The session was quite wholesome. It was quite self-explanatory.
yeah, but
Really enjoyed it.
thank you, Manya. But let's see everyone has enjoyed or not. Uh,
Can we get some feedback for the speaker or the session? Are you there or not? Anybody
there are
can
a lot of
reply on the chat box or can switch off the mic.
I guess there are no questions. So
Yeah.
so Aditi has told great session, sir. But I would like to know, Aditi, what have you learned? Means you have learned something or not from this session or not? So
Neelam has said, thank you, sir, for the wonderful session. So I guess there are no questions. Uh, so let's conclude the session.
okay, thank you. So
Thank
I guess
so
I should
thank yeah,
leave the
thank you,
session
sir,
right
for
now.
yes, sir. You can leave. Like, thank you for this informative session and for this wonderful presentation. It was quite an informative session. So I would like to thank all the participants for joining in today, and the certificates will be released within 2 weeks. So hope you will stay connected on the WhatsApp group. The updates will be provided there. Thank you, everyone.
Thank you, everyone. Thank you, Manya. I'll take your leave.